welcome to the first Raitt Law podcast. Once again, I'm Bobby Raitt and my co-host and partner, Tom James. We are hoping we're giving you information in these podcast episodes that help you if you're ever in the unfortunate circumstance of needing a personal injury attorney because you've been injured due to the fault of another. And this episode is going to be interesting for us because we do have some frustration in doing what we do because we can only do so much to help our clients. And our clients have to help themselves in some respect. So what we're talking about today is quote unquote case killers. And really all we're talking about is things that our clients need to do and things that they shouldn't do to help their own cases. And I'm going to start off with a couple. Tom will chime in and we'll get through, I don't know, probably a dozen of these at most that are probably most prevalent in our practice. And again, if you've listened to earlier episodes, you know that Tom and I have been doing this a long time, a combined over 50 years of practice in the personal injury space. And we've learned a lot of what makes a good case and, of course, a lot that hurts the cases. And I would say from an auto insurance, auto accident standpoint, those that leave a scene and don't file a police report, those that don't file a claim with their insurance company, that's a rough start. That's a rough start to a potential claim. And we tell all our clients, first of all, it's the law. You're not supposed to leave the scene of an accident without filling out a police report or talking to a police officer who will fill out that report. And part of these auto, truck, motorcycle accident cases start with who was at fault, right? And there's no better way to determine who was at fault than to start out looking at what was recorded by the police officer that day. Not always correct. You know, we take a lot of police reports and we look at them and we kind of turn our head and say, well, that doesn't sound right. But the truth of the matter is, if you left the scene of an accident, now all of a sudden we got to start explaining things for you. We got to start to reinvent why you left the scene, how you weren't at fault, because there was nothing recorded on site, right? So that's number one. And then number two is you have to have insurance when you're driving around in the state of Michigan, or you can't bring a claim. If you're driving a vehicle you own, and that's part of the qualifier, you own the vehicle, you're driving the vehicle, you don't have the necessary insurance coverage, you can't bring a claim for your injuries against perhaps the at-fault driver at the scene. So we tell people, make a police report. By all means, don't leave the scene. Call your insurance company as soon as possible. Tell them what happened. The other part of that with the insurance claim is when you call us, we will help you. But initially contacting the insurance company, there's nothing wrong with doing that before you call an attorney to simply tell them about the accident. We try to warn people not to start filling out a lot of documents and things where you might not know exactly what you're filling out until you talk to us, but file that insurance claim, make that police report.
One of the services that we provide, if you call us early enough, right, is that important insurance documentation, filing the claim with your insurance company will help with that process, right? I mean, there's certain documentation, certain things you have to sign. A lot of people have questions about it, like, do I really need to return this to my insurance company? Do I really need to allow them to order my medical records? All of that stuff, right? Just get a hold of us, call us, ask us, and we will definitely answer those questions. So, and that's just building on what Bobby was just saying. Another thing, right? I want to add like number two. Let's talk about number two. Is while it's a good idea to set up a claim with your insurance company and alert them that you were involved in an auto accident or an auto collision, you don't want to start talking to the other person's insurance company. So we've covered that a little bit in the other podcasts, but do not take those calls. And these insurance adjusters are smart. Don't you know, they're smart. They've been doing this for decades. They record every conversation, and they aren't just calling to see how you're doing, right? They don't care. They don't care how you're doing. What they're doing is they're trying to start either an audio paper trail or a written paper trail of how they can start chipping away at your case if you end up having one. So the best thing to do is don't call them back, right? As soon as another insurance company, the other person's insurance company calls you, just say, hey, look, I'm not answering any questions at this time. Hang up and then call us. And then that's where you can use that 866 Raitt Law, right? Just call us at that toll-free number. But, kind of building on to that, here's what's happened to other people, right? So we're telling you, look out. But at our last firm, a person came into the office and they were roughly about 3 to 4 months out from when their collision occurred. And they said, "Hey, can you help me out? I was involved in this crash. I have these injuries." And it was a good case, right? It was a really good case. I'm like, absolutely, we can help you out. And so I gather the information. We have our meeting. We meet with them in person. I call the at fault parties insurance company, and I'm like, "Hey, we represent, Mr. Jones, and for the injuries." And they're like, "Oh, sorry, we already settled with him. It's all done." I'm like, "No, I just met him, right? How could you have settled with him?" They're like, "Oh no, we spoke to him within the first week, and he took a payout." And so we're like, "Wait a minute, what?" So I call my client. I'm like, "Hey, look, they're telling me you already signed some paperwork and you already settled your case." They're like, "Oh no, yeah, I did get some money, but they told me that was for something else." Right? They told me that was just to help me get started to get some bills paid. That's not what it was. So we got the paperwork back, and the paperwork clearly said in there, "This is a dismissal of all of your claims for $5,000." They settled all of their claims. And because the client just didn't read the paperwork properly, didn't ask an attorney's advice, didn't ask my advice, our advice in time, she signed this paperwork and she was done. There was nothing I could do. You can't get that changed. You can't get that reversed. She got tricked. The adjuster probably got a promotion, and this poor woman is left without recovery. Awful situation. But it reinforces what we tell people all the time: do not talk to the other side's insurance company. Call us first.
Yeah. I mean, to make the point even hit home more, when you started with Raitt Law, we had that one potential client who was referred to us. One of the most gratifying things we get is referrals from attorneys that represent companies and insurance companies. And here was a guy, I've had cases with him for years, good guy, mutual respect. He was approached on an airplane by a guy who had an auto accident, who recently had a brain tumor diagnosed. And his surgeon was telling him it was trauma related. Have you been in any accidents? And I think 6 weeks, 7 weeks before, he was in the accident. But he signed a release with the insurance company before he got that MRI result and the surgeon's opinion back for peanuts. And he was trying to see if he could get out of it. And this attorney, defense attorney, is referring him to me. And we try to think of some exceptions and look at the law and stuff. And depending on some very, very minor cases where if the person clearly has a head injury, it's known to the other side, they force them to sign something, they can't know what they're, these are going to hold up. So again, you don't know what's going to happen in the future if you've just been in an accident. This guy had a headache and he thought that was it, so he signed it. Turned out to be a brain tumor, and he was stuck with whatever, $1,500, something like that. It was really sad. So yeah, definitely, if you're hearing from the other side, tell them you have an attorney. If you don't, go get one and then tell them you have an attorney and have them call us. I tell clients all the time, have them call my cell phone. I'll talk to them and I'll explain to them. And a lot of times they want a statement from you, right, Tom? I mean, they want to take your statement
Every time.
and
Every time
for you to go, and not saddle up with an attorney that knows what he's doing or she's doing, and to do it on your own, that is recorded and that's going to stick with you throughout. So there's been many times when we sign up a case real early on, and Tom will sit there with them in that statement. We'll set it up so Tom can be there with them. He can prep them. He can explain to them, and he can make sure they don't do harm to their self or their potential claim. And it's very important to have someone there that knows what they're talking about in these areas. Absolutely.
Yeah. I mean, they always try and take advantage whenever they can.
Yep.
So,
Yep. Another area that we see that really limits our clients' cases is if they're injured and they're not one of these that want to go to the doctor. We get that, right? Documenting your injuries are so important. Tom tells every client we have that the medical record is it. It's not like a TV show, right? It's not what you say. It's not what you're going to get up on the stand and blow everybody away. It's what the doctor says you have. It's not what the person asking for money you say you have. So go to the doctor, get the MRI or X-ray. make sure you do it early and often and follow the doctor's orders. That's very important, right? Because there's no better defense than, yeah, you might say that you have this, but didn't the doctor tell you to go get your head evaluated to see if you had a head injury? You never went. Or didn't you stop the physical therapy short of the discharge when they wanted to discharge you because you didn't think it was helping or you didn't like something? So to document your injuries, to follow through with doctor orders are just integral and very, very important to help us help you.
Yeah, yeah. And so, rather than start a new topic, I think just another one of these case killers. I want to build on that one a little bit. So, what for the average person, right? So, the average person who's never been through a lawsuit has no understanding of how insurance companies, right? The insurance companies that we're fighting value cases um, in order to offer a settlement, right? And so most people want their case settled. They don't want to go to a jury trial and spend 2 weeks, standing in front of there, getting judged by 8 people, sitting at an elevated position. They literally are sitting higher than you, looking at you during that process. And so they don't want to go through this. So we want cases to settle, or they want cases to settle. The way we make that happen, right, is you have to go to the doctor. You have to go get your therapies. You have to get all of these things. You cannot skip it, because every single appointment that you go to, whether it's physical therapy, chiropractic therapy, whether it's for injections or just follow-ups from a surgery, those all get keyed into a giant software package that each one of these insurance companies work with. And in fact, there's been a book written about one of the insurance companies and how they basically created this process of using software to value cases. But it's one of these things where, I mean, everyone's heard the term garbage in, garbage out, right? We talk about it like programming, but it also applies in these cases, because garbage in is no medical treatment. So now there's nothing to be put into the software. So guess what you're going to get out? You're going to get no settlement offers. But if you're prescribed 24 sessions of physical therapy, you go to all 24 sessions of physical therapy, that gets keyed into the computer and software, and then that generates, this case is worth this much. Now, if a doctor says you need surgery and there's a surgery recommendation and you get it, all of that gets keyed into the software. The software then says, this case is worth this much. Adjuster, you can offer this to the injured person. So it all builds upon itself. So there are certain things that don't get put into this computer program. Things like, I like holistic medicine and I'm going to rub herbs on my broken bone because I think that's going to fix it. Do I even need to say that's not going to work to help your settlement or our discussions? It gives us no ammo, right? It gives us no ammo to go into this battle with. So doctors prescribe therapies, get the therapies. Doctors prescribe a surgery or injections. Follow through with all of those, because it'll help us get more data put into those computer programs, which will increase the settlement offers. The other thing it does is it counters one of their arguments that they're going to make, because eventually they're going to argue, well, you're not getting better because you're not trying hard enough, right? So in the law, if you want to like Google this or you want to chat GPT it, it's the word mitigation of damages. Every person who's injured has a responsibility to do their best to get better. So if a doctor says you need surgery to get better and you don't get that surgery and you're not better, well, then the other side argues, well, of course they're not better. They don't listen to their doctors, right? Or you're prescribed 24 sessions of physical therapy, but you only go to 12 because the other 12 are inconvenient to go to. Well, that not only doesn't add to your case, but it takes away from your case, because obviously a person who's too busy to go to their therapies and get their medical treatment can't be that badly injured. Those are the arguments that we face. So please follow doctor's advice. Don't delay in your treatment. Make sure you're doing everything that you can to get better. And in fact, that is our number one instruction that I tell every client when we meet them. You can forget everything else I said, right? I prefer you don't. But if you forget everything else I said, the number one thing that you have to remember, and your number one job in this case, is to get better. Follow your doctor's advice, do your best to get better. Let me handle the litigation. Let Bobby handle the litigation, and we'll do right by you.
And kind of an offshoot of that is I get calls all the time, and I know you do, Tom, as well. I want to go back to work, right? Is that going to ruin my case? Is that going to hurt my case? I have never told one client in my 34 years, whatever it's been, of practice to stay off work for their case. What I tell them is this: if your doctor is telling you that you can't work or shouldn't work, and you go back to work, you're now doing what Tom just said. You're not following the doctor's orders. But if you want to do that, go ahead. But yes, that'll hurt your case, right? And if your doctor is not saying you're off work, then you're not going to have that factor in your favor anyway, and you want to go back to work, go ahead. But don't rush back to work despite what your doctor is saying, unless you don't care that it's going to negatively affect your case. It's the same thing, following doctor's orders, and that's one of the biggest mistakes people make in that respect as far as work loss is, I know you say you were having problems at the job, your doctor disabled you, but yet you went back and worked. And you hear all the time, yes, but I have to because I need money. Well, you have auto insurance, and that's a whole nother episode, but you have auto insurance and you have 3 years of potential wage loss from that auto carrier if we're relating your disability to your injuries from the crash. So don't rush back to work. That's another big mistake. Another easy one, and Tom is all over this all the time, is the social media stuff, right? It's become huge over the years, and every defense attorney, every insurance company jumps right on top of it, right? They want to see what you're doing on Facebook, what you're doing on Instagram. And we tell people, if possible, just stay off. But at least, and I'm going to let Tom roll with it because Tom's much more well versed than I. At least,
I'm so hot on this topic.
At least put your settings to private, and don't jump on there and show us how you are swimming in the beach or how you are running on the sand. It's just not going to help, right? So be careful with social media. Tom, you go from there because it's a hot topic.
I could literally do an entire podcast for hours on this topic about how many cases have been dismissed due to what our clients have posted on their social media, even after we've told them, set everything to private, or please just stop posting, stop doing, all of that stuff. Here's how it harms people, right? Because everyone always comes back, well, I'm not posting anything bad, right? I'm not posting anything. It doesn't matter. It doesn't matter, because I'm telling you right now, no one posts things on Facebook or Instagram, or no one's making TikTok videos that they're sad, right? That they're injured. Oh, look how injured I am. We take these photos when we're at joyous events. For example, my kids just started school again, right? All of our kids just started school again. So we take these great pictures. Hey, first day of school, we're all standing around hugging, right? Or we get to go, it's someone's birthday and I'm at the birthday party, and we take pictures and everyone's hugging. Or you go to a wedding, same thing, right? These great photos, everyone's smiling and happy. It doesn't matter that as soon as you sat down from taking this photo that you smiled, that you had to stay seated for the entire wedding reception or the birthday party, all these other things, because you just posted something on Facebook that's going to contradict not only your medical records, but the statements about my disability, the statements about all these other things. So we always have to keep that in. Well, I say we always have to keep that. People involved that are injured, right, and have ongoing injuries and ongoing impairments need to always keep in mind that anything that they put on social media will absolutely be downloaded and recorded. It will get down. It's not, it might, it will get downloaded and recorded. And if we actually get to the point where we're filing a lawsuit and we have a case, they will give that to the judge in their request to throw your case out, saying that you're making inconsistent statements, or you're lying to somebody because you're saying you're disabled, yet you can ride a roller coaster over here. And that's exactly what happened to one of my clients. This was about probably about 10 years ago. 10 years ago, I had a client who was involved in a pretty serious car crash, had some injuries, and then he learned, right, through our interviews and through meeting with us, that there's a disability component. That's exactly what Bobby was talking about, that wage loss that's built into your auto insurance. And so he's like, this is great. And decides that he and his family are going to go on a 1 month trip around the United States, go visit family, go to Texas, Colorado. But while he's out there, he's riding some quads. He's riding a roller coaster. He went down a water slide. Now he was telling me, right, he was suffering through all this stuff, but he wanted to obviously, spend time with his family. So he actually did an okay job. He set his Facebook to private, but he didn't set his friends to private. So then the defense attorney was able to go to his wife's Facebook page, download all the photos that she had been uploading like crazy. He's on a quad, right? He's on a water slide, a few other things. They gave that to the judge, and the judge threw the case out. There was nothing we could do at that point, right? There was nothing we could do at that point. So please be mindful of your social media posts from the moment that injury occurs until whatever case resolution we have is all done.
Yeah, I learned it the hard way when I was a young attorney. I was in a trial and I was handling a case for a young man that got just pummeled in a fight at a bar. And we learned that the assailant had been kicked out of the bar prior for such an action. So we were able to keep the bar in. And it's very difficult law in this state to keep a bar in with this type of thing, with a fight. But we were able to do it. The defense attorney who handles hundreds of these type of cases was just mortified. I can't believe we got to go to trial. We go to trial. We got a very small verdict. And this guy claimed, he had a tooth knocked out, he had a broken nose, and he had a black eye, and he was claiming that socially he was having problems, that he didn't go out very much anymore, blah, blah. So we go back and talk to the jury after we got our fairly small verdict. Now, mind you, the defense attorney was just so upset that there was even a trial, let alone. I was upset that we only, I forgot what it was. It was like we got $5,000 or something. We were looking for like 75 grand, say. So we go back there, and the foreperson, the head of the jury, says, you might want to tell your client to stay off Facebook. And this was before, attorneys were making big deals about this on both sides, or else I might have got, the heads up on it. So we run back to our computers, we pull it up, and right there, like his second picture, he has a beer in each hand, a woman in each arm at the bar a month after this fight. His eye was still black. He looked like he was absolutely fine. Like he was not socially inactive at all. So from that moment on, it was a red button issue for me. It was a hot button issue for me. It was something that really, it can kill your case. I mean, that's what we're talking about, is case killers, and that's right up there in the biggest ones.
Some savvy clients, because I've told that same story, because I remember that trial. I was there at your trial, right? Bobby and I didn't actually like work on the same team. We both led our own teams at the last firm. But whenever one of us would go to trial, you'd always go and check it. We'd always go and watch them and see how they're doing. And I remember that trial, and I remember the verdict. And so, but that, that issue sometimes with these when you get savvy clients that are like, hey, how is it that the jury did their own research if the defense attorney didn't tell them, right? Aren't juries not supposed to do outside research? Well, that is 100% accurate.
You remember?
Yeah, afterward.
Yeah. And it got
right.
denied.
And it got denied because you know what? And well, the judges are going to say that, it's going to stick no matter what. They're not going to.
Not every judge,
but you got to try. You got to try.
Not every judge.
But the thing is that, juries do what they're going to do. The judge is going to say, you have to follow the law. You can't do your own independent research, but every single one does independent research. So, don't try and fall back on that kind of reasoning. If you have that kind of
special. Yeah, I mean, the defense attorney didn't do it. And he was a really good, skilled, experienced defense attorney that handles these type of cases all the time. The jury did it. And, like Tom's saying, there's a jury instruction right on point. In general, it says don't do your own. It's like only consider what you hear in court, in trial, during the trial. No outside, no newspaper, no. So we were right on point. Once we learned it, we brought a motion for a new trial. And this judge, I'll never forget it, he says to me, Mr. Raitt, if during lunch the jury saw your client in the parking lot doing cartwheels, would you think that's outside research? And I looked at the judge and I said, why don't we just talk about what happened here? Because to be honest, I really don't know where you're going with this judge. He was one of these funny, kind of goofy. He was a great judge. He was a nice judge, but he was kind of all over the place. Because honestly, and I think you would admit this, Tom, I mean, we had a really good chance with a fair-minded judge of getting a new trial because that's clearly against the jury instruction. And the problem is, you most often you don't have that evidence that the jury went against the jury instructions. We had direct evidence, but it didn't matter. But the bottom line is just stay off of social media as much as possible. That's really it. The next one's a no-brainer, right? We tell our clients all the time, just be honest. Just be honest, because lying, exaggerating could kill your case. The most atrocious situation is where our clients tell a story, whether it's in a statement they give to the insurance company, what they say in their deposition about something very specific they absolutely can't do. I never take out the garbage anymore. And then a month after that deposition, we get a video of our client taking a large screen TV and putting in the back of a pickup truck. Case over. It's not just the fact that, hey, he can really do that. It's the fact that, hey, he can really do that and he lied about it. So then what else did he lie about? So then they have the ability, whoever's judging the case, the adjuster doesn't think anything of the case anymore. The defense attorney doesn't think anything of the case anymore. The judge and then eventually the jury is going to think this person's lying. It's happened to us numerous times, despite what we always counsel our clients to do. And that starts right from the beginning, right when you're talking to the police officer, when you have to fill out the paperwork for the insurance company, like Tom mentioned earlier in another episode. Call us before you fill that out, right? Because you might think you're answering a question correctly and perhaps you're not, and it might look like you're lying. Or you might be thinking you're making your own case, which is a whole nother client killer when you try to go out of bounds, so to speak, go to Chat GPT, do your own thing to try to make your case. And one of those things you're doing is exaggerating to try to tell people how bad your injuries are. If you're caught in a lie because of that, you've ruined your case. I'm sure Tom has a lot of examples of that.
Oh God. Right. That's probably the one that we have the most examples on. But you did a great job of like just describing how exaggerating is awful. I'm going to do like a little spin on that though. So that's like what people do to try and build their case, and some people exaggerate. Now the other thing that sometimes we get is that people will hide information from us initially. So as you can imagine, one of the most important questions that we have to answer for any personal injury case is the injury came from the event, right? So my back injury that required surgery was because I was rear-ended, not because, right, I'm 57 years old and I have, herniated discs in my back, or I have arthritis in my back, whatever terms they want to use. So what'll happen sometimes, or what has happened, is that we have our very thorough first meeting with our clients. This is the one that we've talked about in prior episodes. We bring everybody in, we're face to face, and I'm asking you questions like, what are your injuries? And then I'm also asking questions, have you ever had injuries to that body part prior to this collision, fall, injury event? And I get it a lot. No, I've never had an injury to this thing. And I'm like, all right, number one, right? You're as old as I am, right? 57. So you probably had some event. What about football? Did you play high school football? Yeah, I played high school football. And you're telling me you never hurt your back. Well, I didn't know you were talking about that far back, right? So that's one thing. And maybe that person's not hiding the information so much as they're just not rationalizing that things that far back can have an impact on things going on now. They can, and they do. So other things that are hiding would be, sometimes I'll get clients that do just straight up say, no, I've never gone to the doctor for any kind of back pain. We order their records, and we do this before we file lawsuits. Come to find out, a year before the car crash or the slip and fall, they had gone to see a doctor about back pain. And you look at the records and it's very similar in the way it describes it. My pain is 7 or 8 out of 10, 7 or 8 out of 10. And you're like, oh my God. So I'll call the clients and I'll be like, hey, you told me that you never had any back injuries, but I'm looking at a medical record right now where it says that you did that, you had these similar complaints 2 years ago. Oh, I figured if I told you that, you wouldn't take my case and it would hurt my case. Well, actually, the opposite, right? Not telling me hurts your case and we might not keep the case. However, if I can get it in time, I can convince them that if you have prior injuries, it doesn't necessarily hurt your case. And in fact, in some situations, it actually helps explain why you have this injury from this event, especially in car crash cases where there's very little vehicle damage, right? So you'll see these car crash cases where it looks like the cars literally were thrown into a blender. Nobody ever questions, right? Oh, did you get injured in the car that looks like a blender now? It went through a blender? No. But what about the little bumps, right? Where it doesn't leave a lot of visible damage. I mean, underneath the plastic, everything's bent, but on the outside of the plastic, it doesn't look like anything happened, a couple scrapes. Well, how is it that someone needs back surgery after an event that didn't cause the car to look like it went through a blender? Well, it's because there was a pre-existing condition there, right? Whether it's arthritis, an existing disc bulge, disc protrusion, disc herniation, whatever label we want to put on it or the doctors put on it, that shows that structurally things were not perfect. You weren't a 16-year-old high school football player ready to go, right? You're 57 years old and had a normal life. And so that provides an explanation as to why that type of injury occurred from what appears to be a lower impact collision. And that's okay because our law allows for it. Our law says that if an injury is aggravated or exacerbated from a pre-existing condition, you can still recover. A lot of people don't know that. Once we explain it, all of a sudden we get a lot more information out of people too, out of our clients. Please tell us everything because you can still have a case and it actually becomes stronger at this point than it was
Maybe we
earlier.
should show up at the initial client meetings with jury instruction 50.10. That's what it says in 50.10. I use it in every jury trial because there's always a sense of what's aggravated. But in general, what Tom is saying is we can't help you with it if we don't know about it. We are your advocates. We are your voice. Tell us everything. Don't hide it. We can deal with it. We can deal with it. The worst case scenario is when we find out from the defense attorney or when we find out from the insurance company something that your own attorney didn't know, and now we have to scramble, right? So tell us about it up front. That's the most important. We're going to talk about this in another episode, and we're running long, so I'm just going to touch upon it real fast. In this state, as we've mentioned a couple different times throughout the episode, you have to have insurance, right? We can't do anything for you if you don't have insurance on a car that you own and you're driving. But the other couple things is, and this is a huge topic for one of the later episodes, is you have to have a certain kind of coverage to do the best on your claims. Two aspects of that. There's something called uninsured motorist and underinsured motorist coverage. That means you'll be able to collect coverage or be able to get money if the wrongdoer, the at-fault driver, is either uninsured or has a low amount of insurance. You can then key into those coverages on your own policy to get additional money. And then the other thing is with the change in the law that we touched upon a little bit, that we're going to talk about a lot later in one of the last episodes, the new law says that you don't have to have unlimited personal injury protection or no-fault coverage. You can have lesser coverage. We educate and school all of our loved ones, all the people in our life, all of our clients, stick with unlimited. It's a little more money now, but it's going to save you a lot later. And we will touch upon that in much greater detail in future episodes. So I just want to sign off by saying thank you for tuning in. You can tell whether we're talking about helping clients with things that they might do to hurt their case or helping clients with things they might do to help their case to show them how to do it better. We know what we're talking about. We've been doing this for a combined 50 plus years at Raitt Law. So call us 866-RAITT Law, RAITTLAW, or go to our website, www.firstraitlaw.com. Thanks for tuning in.